The first speaker to kick off the conference you know well. Glenn Taubman has been a staff attorney at the National Right to Work Legal Defense Foundation for a little over 40 years. As a staff attorney at the foundation, Glenn has represented employees across the United States before the National Labor Relations Board, as well as federal courts. Last year, Glenn introduced us to a case he had just filed on behalf of 6 professors at the City University of New York. Today, he will be giving us an update on what has happened in that case over the past year and why he believes the case may actually make it all the way to the U.S. Supreme Court. And as a short special after Glenn's presentation, we will be sharing a video that Abraham Goldstein made discussing his case and why he brought it, with Glenn's help.
Thank you, Amanda, for that warm introduction. Yes, I have been here for 40 years here at the National Right to Work, doing work that is rewarding and fun and just a joy to do. And I want to welcome all of you to the CEAFU conference and tell you a little bit today about one of our most important cases, which is called Goldstein versus the Professional Staff Union and the CUNY, the City University of New York. Goldstein is now pending in the U.S. Court of Appeals for the Second Circuit. And as you will likely hear today, and as I'm sure you know, we won a stellar victory in the Janus case a few years ago. Janus was the case that outlawed all forced dues in the public sector so that no teacher, no public employee anywhere in the United States can be forced to pay dues as a condition of employment. The Goldstein case is seeking to take Janus to the next level because it's one thing to say that nobody can be forced to pay dues as a condition of employment, but the other question that Goldstein raises is, why should somebody be forced to be represented by a union that they don't want, that doesn't represent their interests? And that's the key question that we have in Goldstein. So Goldstein has 6 college professors from the City University of New York. The lead plaintiff is Avraham Goldstein. He is an Orthodox rabbi and a citizen of both Israel and the United States. Several of the other professors are Orthodox Jews with close ties to Israel. They are represented against their will by a radical far-left union, the PSC, which, rather than representing the teachers on their campus, seems to spend all of its time on foreign policy, like demonizing Israel, the boycott, divest, and sanctions movement, and things like this, taking political positions that are completely contrary to the deeply held religious and other beliefs of the professors. And so these professors came to us and said, we don't want to be represented by a union that we consider to be anti-Semitic, anti-Israel, and that stands for everything that we disagree with. And so that's really the fundamental question in Goldstein in this case is, it's one thing to say, as the Supreme Court said in Janus, you don't have to fund a union that you don't like. But the next question is, well, then why should I be forced by the state of New York to be represented by a union I don't like? And it's not just representation in sort of a generic sense. It's representation for purposes of wages, hours, working conditions, grievance processing, etc. So these professors are being forced to be represented by a union for purposes of their wages, their working conditions, and all of their benefits. They're being forced to be represented by a union that stands against everything they believe in. And, you know, if you put this in other contexts, like going out to hire a lawyer, say you had a commercial dispute and you went out to hire a lawyer, and the state of New York said, oh, by the way, we're going to assign you a lawyer, whether you like it or not, and we're also going to assign a lawyer who hates you and who stands against everything you believe. And you have no choice. This is the only spokesman that you can have, because we, the state of New York, have determined that this lawyer is the only spokesman that we will allow you to have. Well, that's really what's at stake in the Goldstein case. So we filed the Goldstein case. We went through motions and discovery, and the district court in New York ruled against us, which is not a surprise because the Supreme Court precedent has not been good on this. For 50, 60 years, the Supreme Court has upheld the concept of exclusive representation. They've said, well, there's nothing wrong with exclusive representation because the union owes you a duty of fair representation. So even though they may hate you and you may hate them, they still owe you a duty of fair representation. So there's nothing wrong with this. And you know, the lead case that created the duty of fair representation was a case called Steele versus Louisville and Nashville Railroad. And in Steele, it was black railroad workers who were being discriminated against by the union. And the Supreme Court said, well, it's okay for this union to continue to represent these workers, and it's okay to force the union on these workers because we're going to create this thing called the duty of fair representation, and that'll protect these workers. Well, the Steele case is now something like 60 years old, maybe even more than that, and it's time to review the Steele doctrines in light of Janus, because Janus said, we understand why people want to disassociate from unions and union speech. So Goldstein is taking it to the next level. We're just beginning briefing in Goldstein. I imagine, if I had to guess, it would be about the fall of this year before we have oral argument in Goldstein. And it's pretty clear that whoever loses is going to the Supreme Court because they're really the only body that can fix this problem of forced union representation, right? It's not enough to say you don't have to pay. We want people not to be forced to be represented by a union that they despise and that, in fact, despises them and may well be violating their religious rights in the sense of these are people who have firm religious beliefs, but yet they're being represented or being forced to be represented by a union that is totally against their religious beliefs. So that's the Goldstein case. It's part of our continuing efforts to push Janus into other spheres. And as I said, you'll be hearing about Janus from others, probably Bill Messenger, who argued Janus. And I would just conclude by saying, please be aware of what your rights are. Please be aware of what's going on in your school system, on your campus, wherever you are. And remember that the National Right to Work is here to help employees fight all sorts of compulsory unionism. We've been doing it for almost 60 years. I've been doing it for 40 years, thankfully. And we continue to press on these issues. So know what your rights are. Go to our website. We have whole sections there about your legal rights. Spread the word about the foundation and what we do. And we are just happy to help teachers and workers all across America in any way we can. So thank you for your attention. And I'm sure Amanda will be available to answer any questions you may have. Thank you. Have a great day.
Hello, my name is Abraham Goldstein, and I would like to thank National Right to Work for granting me the Applegate Award. Let me briefly introduce myself and tell you our story at the City University of New York, which is also known as CUNY. So I was born in the former Soviet Union in 1971. 2 years before I was born, my parents asked the Soviet authorities for permission to leave the Soviet Union and immigrate to our homeland, the state of Israel, being we're Jewish. Soviet authorities denied my parents and our family the right to leave Soviet Union for 15 years until 1986. During these years, my family and I experienced persecutions for our Judaism, which we practiced, and our Zionism in the Soviet Union. In Israel, I got my bachelor's degree in mathematics from Technion, and then I came to the graduate center of CUNY to pursue my PhD in mathematics. It was in 1994. In the beginning of 2003, I defended my PhD. And during these years, I worked in Lehman College, which is part of CUNY, as adjunct lecturer of mathematics. And in 2006, I got a tenure-track assistant professor position in the mathematics department of the Borough of Manhattan Community College, which is also a part of CUNY. And I'm still at the Borough of Manhattan Community College. So as you can see, I've been involved with CUNY for over 25 years now, in one way or another. So in the fall of 2018, I was approached in my classroom in BMCC by the representative of the PSC CUNY union after I finished my class. And this representative told me that due to some lawsuit which was recently won, and that was Janus, of course, but I was not aware at the time, we all are automatically not members of the union anymore unless we reapply by filling out and signing this blue card. And the rep gave me the card. Being a little bit careful, I told the rep that I can't sign something before I talk to other people, study the card, and so on. So I took the card, I went to the math department, and I asked my colleagues there who are more aware of what's going on with unions and bureaucracy and all that stuff. I'm more into research and teaching. So my colleagues told me, yes, we all were told about this card, and this is what everyone does, and this is fine. So I filled out the card, and there were 2 places to sign on the back, and unfortunately, I didn't do a due research. I signed, and about 2 weeks later, the rep came again and asked me if I decided to sign the card and submit it or not. So I told the rep, yes, I decided to do it. And the rep told me, good, because otherwise your benefits like glasses, which are covered by the union, and prescription drugs would fade out because the union would not continue giving it to you without you being the member after some time. I said, okay. That was not my calculation of why I signed the card, but okay, even better. And I gave the card back. Okay. Now let's move to 2021. In 2021, there were elections in the PSC CUNY union, and the new group, much more radical, outspoken, and extremist, came to power and started to push forward their agenda. The union started passing resolutions about Chinese-American relations, accusing the Biden administration in, I believe, May of 2021 in being racist against China. Then there was a resolution in June against my country, the state of Israel, accusing Israel of being a settler colonial state from 1948 and committing genocide of Palestinian population. At that point, many of my colleagues at CUNY, Jewish colleagues and non-Jewish colleagues, and myself decided that we no longer can be members of that union, and we wanted to resign. So we wrote our resignation letters. At that point, we were informed by the union, or some of us were informed, that we are committed to the union. We cannot resign. Those of us who signed this blue card are not allowed to resign the union. We have only a 10-day per year window when we can resign. If we try to resign at any other time, our resignation is not fully is not a full resignation, and the dues will be still collected unless we resign during those 10 days a year. Now, most of us didn't even get that reply from the union. For example, I sent my resignation and there is nothing. The dues are still being collected. At that point, I wrote to the H&R department of Borough of Manhattan Community College, informing them that I resigned from the union. They ignored it. And then I was informed by my colleagues that some HR departments told us that they are not allowed to talk to us. The union, being our sole representative, is the only one who can tell them that we are no longer members of the union. So that situation was unbearable. And at that point, I contacted the National Right to Work. The National Right to Work took our case. It was me and several of our colleagues, and helped us to bring the case to the court. What I found out is that even after I resigned from the union, and I did do it during those 10 days later on. I caught those 10 days. I forced the union to tell me when those 10 days are, and I made sure to resign during them. Even after I did that, the union is still my exclusive sole representative, and I cannot free myself from that dreadful, horrible representation. And when the union comes out with political statements, which should not be part of what the CUNY union representing the instructional staff at CUNY should be concerned with. And when they say we have 30,000 people behind us in our statements, I am still counted as one of those 30,000. And when the union makes a decision to do certain things in terms of our rights or giving up our rights, they still do it in my name, even though I don't want them to represent me in any form or way. So I'm very thankful to the National Right to Work and to the other groups who help us, several professors in CUNY, in our lawsuit against the PSC CUNY union to free us from being misrepresented by the union without our consent and against our will. Thank you very much for listening to me, and I'm looking forward to the times when in United States of America, people will be able to decide themselves who will represent them and who will not represent them. Thank you very much.